Hi everyone, I'm Nithin. I'm intern at ubAdvocate. I'm pursuing my first year LLB. Today I'm coming up with a topic, a legal topic, standard form of contract. Today I'll be discussing about it. So I'll begin with the introduction. So overall set laws today has developed from its past principle. Advancement of regulation had given answer of these issues in the frame of complying with the request of conditions of present day. So we can see that to day-to-day transaction, the contract and agreements are wider in nature and it is very essential in today's scenario. So Anson states that the contract is a child of commerce. According to the Indian Contract Act 1872 section 2H says that an agreement which is enforceable by law is a contract. Moving further. So the meaning of standard form of contract is generally the terms and conditions of the contract that are pre-drafted by the one parties and the other parties is supposed to sign it without having any time or opportunity to get the terms and conditions to be changed. Standard form of a contract is a type of contract where there is no scope of negotiations. And we can see the Blacklaw's dictionary definition. A standard form of contract is defined as under contract is ready by one party and to be endorsed by other party. In more fragile position, generally a shopper who has not much of a choice about the terms, also termed as a contract of adhesion, adversary contract, additionary contract, take it or leave it contract, linear contract. For example, we can take that an insurance company may prepare a draft or insurance policy which may form the basis of contract with a large number of insured persons. Another example like the railway authorities may print various terms and conditions in the timetable, which may be deemed to the basis of contract with thousands of passengers, which may be traveling by rail every day. So coming to the legal status of standard form of contract. In Indian contract system, the standard of form of contract falls under the category of Indian Contract Act and it has no separate legal provisions in it. And because of heavy industrial development, this sort of contract has become normal in nature and executed in numbers in nowadays. And this had prompted a request of detailing a fledged rules on the standard type of agreement and to safeguard the privileges for a more vulnerable party in the standard type of agreement. There are certain rules made by the legislature which seems to be unreasonable like in United Kingdom. Section 3 of Unfair Trade Contract Terms Act, it limits the liability of drafter on the consumer or limits the provisions of standard of contract to the drafter. So we will move further. So limitations of liability by one party. There should be a contractual document between the two parties where they are going to enter the standard form of contract, and there should be no misrepresentation like fraud, mischief, and other elements, and it will become by the contract will become void. And there should be a reasonable notice on the contractual terms, and there should be notice should be contemporaneous with the contract and the terms of contract should be reasonable and the strict interpretation of the exemption clause it means the court makes the strict construction of the contract to give the protection of the weaker party here in case where the parties to the contract do not have a bargaining quality or one party is likely to have undue advantage at the cost of other so that the other party may get unjust enrichment against a weaker party and the last is theory of fundamental breach, another device which has been appointed to protect the interest of weaker parties to the contract when they have unequal bargaining position is to see that the enforcing the terms of contract does not result in the fundamental breach of contract. So in standard form of contract, there will be contract between two parties and there will be no privity of contract. So we can see that how the liability towards the third party to the case law of Morris versus C.W. Martin and Sons. Here in this case, the facts of case is the plaintiff gave her fur garment to the furrier for the cleaning. Since the furrier himself could not do the job, he gave this garment to the defendants for cleaning with the consent of plaintiff. The defendant servant stole the garment for which the plaintiff brought an action against him. So the defendant sought an exemption from the liabilities basis that the agreement between the plaintiff and the furrier. So the defendants were not allowed exemption and they were held. So similarly, in other case laws, we can see that the Olis versus Marlborough, the facts of this case, the plaintiff and her husband booked the hotel room in the hotel. When they checked in the hotel room, they found a slip at the back door which states that the hotel will not be responsible for any lost or stolen articles. Due to the negligence of the hotel staff, the plaintiff property got stolen and they demanded for the compensation from the hotel. The court held that there should be reasonable notice which should be given before the time of signing the contract. So the notice in the room was not forming the part of contract. So the hotel held liable to pay the compensation of the plaintiff. So you can see that there should be reasonable notice and the prior notice should be given. So another case law was Parker versus Southeastern Railway Company. In this case, the plaintiff deposited his bag in the clock room at the railway station, and in return he received the same. He received a ticket. In the front side of the ticket, it was written "C bag." At the back side, it was printed that company will responsible only for the loss of $10 and not more than that. The plaintiff's bag got lost and he claimed for the compensation of the bag, which was more than $10. The court held that company will not be held liable because the company take the reasonable notice earlier and the plaintiff consented that he already knew that there was something written back at the ticket and did not see that it was his mistake because he thought that ticket were mere receipt that money paid. So in standard form of contracts, there is no scope for negotiations, and this offers a remarkable chance to the joint organizations to take advantage of the shortcoming of the person by forcing upon him terms which frequently seems to be a sort of confidential regulation and which might go to the degree of excluding organization from all risk under the agreement. The courts have advanced and applied specific guidelines to safeguard the interest of the purchaser, client, or a traveler as the case might be upon whom standard structure agreements or exclusion provisions or forced and sensible notification ought to be given, notice ought to be given of contaminates with the contract hypothesis of essential break, contra profound interpretation of agreement risk is misdeed exception statements are outsiders so forth.